Good afternoon to you. Today we will take up Article 324 dealing with the appointment of Chief Election Commissioner and other election commissioners. This was in the news recently because the 5 judges Constitution Bench of Supreme Court has questioned the procedure being followed by Government of India in the appointment of Chief Election Commissioner and election commissioners, and also suggested that the Chief Justice of India should be included in the appointment committee for the selection of these dignitaries. Of course, the intention is to ensure neutrality. Supreme Court also pointed out that though Article 324 stipulates for the enactment of a law to provide for the procedure of appointment of Chief Election Commissioner and election commissioners, no law has been made by the Parliament so far. As a result, that such appointments are continued to be made by the Union Executive without any support of law. Secondly, Supreme Court has also observed that the silence of the Constitution in this regard has been exploited by all. No doubt, the CEC and Election Commissioners Conditions of Service Act 1991 has envisaged the tenure of Chief Election Commissioner and election commissioners as 6 years or 65 years of the age, whichever is earlier. Most of the Chief Election Commissioners appointed so far enjoyed less than 6-year tenure, though the Act specifically says 65 years or 6 years of tenure, 65 years of age or 6 years of tenure. Remember, from exam point of view, you should keep in mind the Constitution has no specific provision on the tenure of Chief Election Commissioner or election commissioners. Instead, this has been left to the Parliament, understand, Parliament, to make an appropriate law and rules thereon to govern these points. Accordingly, 1991 Act has been made providing the tenure as 65 years of age or 6 years, whichever is earlier. In addition to this, Supreme Court also questioned the undue haste in which the appointment of Mr. Arun Goyal has been made as election commissioner. Of course, remember, most importantly, these observations of Supreme Court are only obiter dictum, otherwise called side remarks, and not supposed to in any way indicate the final judgment of the apex court, which has been, as you know, reserved. So this cannot be a clue. It is up to the Supreme Court to interpret the provisions of the Constitution as well as the procedure. They can question the procedure. That is a totally different matter. We are not here to judge it. We are concerned only with from the point of examination. Secondly, another point you should remember is, what are the possible questions in this? Number one, Part 15 from Article 324 to Article 329 deal with the Election Commission. First point, because this is important from an exam point of view. Secondly, the Election Commission is to consist of one Chief Election Commissioner and two or such other number as may be decided by the President, but at present 2 election commissioners are there. So, second point you should remember, 1 CEC plus 2 ECs. Subject to the law made by the Parliament, the CEC and the election commissioners are appointed by President. Who appoints? President appoints. Again, the service conditions, tenure of the CEC and ECs are governed by a parliamentary law, as I already told you, 1991 Act, which I mentioned. As mentioned, remember, they continued to hold the office for 6 years or 65 years of age, whichever is earlier. CEC and ECs, Chief Election Commissioner and Election Commissioners, enjoy the same status, receive the same amount of salary, perks as the judges of Supreme Court. And as far as the salary, perks, privileges are concerned, they enjoy, both the Chief Election Commissioner and the election commissioners enjoy the same. But remember, as far as removal is concerned, it is a gray area. For the purpose of removal of election commissioners vis-a-vis Chief Election Commissioner, there is a large difference, which is important from exam point of view. Chief Election Commissioner is kept at a par with the Supreme Court judge. That is, Chief Election Commissioners enjoy absolute security of tenure. Absolute security of tenure, in the sense that the Chief Election Commissioner cannot be removed except after following the procedures stipulated in the Constitution for removal of the judges of Supreme Court and High Court. How they are removed? After an address by the Parliament, and a resolution has to be passed by both the houses of Parliament by special majority. On the basis of such a resolution having been passed by special majority by both the houses of Parliament, President gets the authority to issue order of removal of Chief Election Commissioner, as in the case of judges of Supreme Court and High Court, CAG and other dignitaries. Remember, this is as far as CAG is concerned. On the other hand, very important, on the other hand, as far as election commissioners are concerned, this security of tenure have not been provided to election commissioners. This security of tenure which is provided to the Chief Election Commissioner has not been provided to election commissioners. Then how they are removed? Election commissioners are removed by President of India at pleasure, remember. However, only on the recommendation of the Chief Election Commissioner. Now the question is, whether the Chief Election Commissioner can arbitrarily recommend removal of election commissioners. That was a question examined by the Supreme Court in the case of Mr. Gopal Swamy versus Naveen Chawla Saab. So in that, Supreme Court said no. It is only an insulation. This provision is only an insulation against the arbitrary use of powers by the executive. That means Chief Election Commissioner should protect the election commissioners from the powers that may be exercised by the union executive arbitrarily. So it is a protective provision. You cannot use this for removal of the what is known as election commissioner. So that point we should be very clear. Secondly, another gray area is, unlike CAG, unlike what is known as judges of Supreme Court and High Court, the salary, allowances, secretariat expenses, etc. of CAG and judges of Supreme Court and High Court, they are charged into the Consolidated Fund of India. They are charged into the Consolidated Fund of India, remember. So they are not votable. You can discuss. Absolutely, there is no bar for the Parliament to discuss about the expenditure incurred by these dignitaries or these officers. But you cannot vote. Lok Sabha, Rajya Sabha, Parliament cannot vote on that. It is charged on the Consolidated Fund of India. Remember. So, but unlike this position, election commissioner, this Chief Election Commissioner and election commissioners do not enjoy this. In other words, they are not charged expenditure, they are votable expenditure. Before talking about charged expenditure and votable expenditure, you should know why. What is the reason? What is the rationale behind the charged and votable, etc.? We have got a Consolidated Fund of India, Public Fund and Contingency Fund. Consolidated Fund of India consists of all the revenue, all the duties, all the excise which have been received by Government of India is deposited in this fund. So the basic rule is, without the approval of Lok Sabha, you cannot draw even a single pie from the Consolidated Fund of India. That is the basic. So when you pay money to any person, Lok Sabha approval is mandatory. Lok Sabha approval means parliamentary approval is mandatory. So now remember there is separation of powers. We have got the powers separated, only not division of power. Division of powers is the powers divided between the central government and the states. That is division of powers in Schedule 7. Don't confuse with that. The other, here we are talking about the separation of powers among what is known as legislature, executive, and judiciary. Executive is to implement the law, legislature is to make a law, and judiciary is to interpret the law. This is separation of powers. Now, to enforce separation of powers, remember, true separation of powers, there are certain expenses incurred by the senior dignitaries, senior functionaries, for instance, judges of Supreme and High Court, and what is known as CAG, and President of India, Speaker, Deputy Speaker, Vice President. These dignitaries' expenditure are taken as charge. They cannot be voted. They are charged. So you can discuss but cannot vote. This is to ensure the freedom of these officers, these incumbents of the officers who are holding it. So that is why such a protection is not available, remember, for election commission. Very, very important point. In this important point, another point you should remember